May please, my lord. I beg to mention item 22. No, please, the matter cannot come to
Just a moment. You're for?
for appellant.
And for respondent.
On premier by the appellant. Matters adjourned. This is after 3 weeks.
Beg to mention item number 17 and 20, lordship, because I am not keeping well for last few days, lordship. Some cold and flu. 17 and 20, lordship.
17.
17 and 20, lordship.
These are same matters.
Yes, lordship.
My lord, similar issue, SSA teacher, my lord. Appointment of teacher, my lord, different school.
Okay.
But the issue is same. My lord, I appear only for this for the state respondents here, my lord.
And I think that
Those are SSA teachers.
SSA teacher, Hindi teacher, my lord.
Hindi. Mr. Sheikh, it's a 2018 matter.
yes, lordship.
Should ensure that it is
On the next day, I'll do, lordship.
on prey made by the learned counsel for the petitioner on grounds of personal difficulty. The same not objected to by the state respondent. This matter is adjourned. List the same after 2 weeks. You're mentioning 17 and,
My lord, I'm in 17, my lord.
And 20.
and 20. 20 same.
Yes, Your Lordship. Your Lordship, I beg to mention item number 14, Your Lordship. I pray for a week's time.
Let it be 2 weeks.
You have to file your written argument.
No, Your Lordship.
What is required here?
It is land acquisition, my lord, where the pleadings is complete. It is fixed for hearing, my lord.
Okay.
So, otherwise the case is ready for hearing.
On prey made by the petitioner, this is matter after 1 week.
Much pleasure.
Your Lordship, it's for item number 15, Your Lordship. For time for 2 weeks, Your Honor, since the Your Lordship, since my senior is out of station.
15.
This is a criminal petition. Oh, it's him of the trial.
Your Lordship's last order, we were directed to produce the status report and the CD. We have it with us, Lordship. If this matter can be passed over for the moment, Lordship.
Your Lordship, my senior is out of station, Your Lordship.
Who's appearing here?
Shri Umesh Kumar Sharma, Your Honor. Lordship.
Who's the affected person? You,
Lordship, the petitioner.
the petitioner. It's with you. The trucks are with you now. On prey made by the petitioner, this is matter after 2 weeks.
Applies, Lordship. Your Lordship, I beg to mention item number 16, Lordship. 16. Your Lordship, 2 weeks time may be given, Lordship.
You're for?
Petitioner, Lordship.
My lord, let it come after 4 weeks because it will be out of station, my lord. Some difficulty is there. It's a matter of appointment. It's no urgency as such.
That Tura Municipal Board.
Bagmara.
Bakmara. I kept
Kindly, my lord.
make mistakes. On prey made by the petitioner, this is matter after 4 weeks.
Much obliged, lord.
Supplementary cost list, item number 1.
But this is the matter, my lord, where Fencidil, my lord, and
This matter was heard, in fact. Only the other side was supposed to bring some authority on record. That was
the report was
Oh,
called.
I think
already report is there.
you have filed the CDs here.
It is here.
I think Dr. Musika is on the issue of the contents,
Not
or rather
contents,
the
that
amount,
coding does not
the
come
amount
within-
of the contents of the.
No, not the amount.
What is your
My lord, my submission is that one capsule is seized, my lord, that is called pentadol. And I placed one judgment that doesn't come within the definition of or within the purview of NDPS Act, my lord. And some bottles of Fencidil cup syrup. That also there are two views, my lord, whether it will fall under NDPS or not, my lord. Because here the quantity is below 0.25, which is required to be designated as a NDPS, my lord.
0.25.
0.25 is required, whereas the quantity per bottle, my lord, whereas this is 0.17, my lord. So, my lord, I am not on that, my lord. My lord, my case is that the contraband was seized from a jeep, my lord, and three people, the driver and who were there in the jeep, they have been arrested, my lord. I am a shopkeeper, and the other one is the owner of the jeep, my lord. Now, it's a commercial jeep, my lord. The driver takes it for hire. Now, how far, had it been a case of direct seizure from our position, my lord, it is understandable. Now, I am a shopkeeper who has nothing to do with this, my lord, and the second petitioner is the owner of the jeep, my lord.
What is your nexus with the other co-accused?
There is no nexus, my lord.
You are a passenger.
My lord, I am the owner of the jeep, my lord.
Okay, you are the owner of the jeep.
Second petitioner is the owner of the jeep, my lord, and this is a commercial vehicle, my lord. I bought it for my livelihood. The driver takes it wherever it is required for hire, my lord. So to impute that I am in the knowledge of things, because some grocery items were being transported from Assam, that Krishna side, my lord, to Meghalaya.
That will come out in course of trial.
My lord.
Not now.
So, my lord, coupled with the fact that whether both these articles are contraband or not, so that is one question, my lord. And secondly, it is not a case of direct seizure from our position, my lord. Had it been a case of direct seizure from our position, my lord, I would not have accepted the brief also, my lord. But this is a case, my lord, of an owner of the commercial vehicle, my lord. For example, like a local taxi, owner, how far, at least some.
But he was there in the vehicle, isn't it?
He was not there in the vehicle, my lord.
Oh, he was not there in the vehicle.
No, my lord, but
the three people who were there in the vehicle, they have been arrested, my lord.
Okay.
So the petitioners are not them before lordship, my lord. The petitioner before your lordship, one is a shopkeeper, my lord, who runs a grocery shop, and this item, some water bottles and juice bottles, my lord, they were being brought from Krishnai to Meghalaya, my lord. Now in that vehicle, they found something like this.
my lord, I produced this CD. First thing, the question raised by my learned friend, the first one, that is whether it comes under NDPS or not, lordship. Fencidil as well as the other capsule that was being seized. First, Fencidil, it contains, we are not into Fencidil per se, but we are into the contents. One of the content is codeine. Codeine is listed in the NDPS, and the quantity also, even 0.7 also, number of bottles that have been seized, it comes to commercial quantity by far. Secondly, the other capsules that were seized, it is an opium derivatives. So therefore, opium also is listed. We are not into the entire content. We are into the specific content. Now, secondly, lordship, about that, they were not in the vehicle, and one of them is the owner, the other is the shopkeeper, where it was delivered.
It was to be delivered, not delivered.
I have produced the CDR. During the loading as well as unloading, they were constantly in touch, meaning thereby they were in conscious possession. So I have got a very strong objection to this ban. CD is there.
Items are recovered from compartment of the vehicle, not from the position.
My lord, from the seizure list itself will show, my lord, page 19 of the petition, my lord, from where the articles were seized.
Seizure could be from anybody. Particularly, it was from the vehicle. But now, as I've inquired earlier, it's only the nexus. Because there is usually a ring. There would be the accused, his accomplice, or whatever. So, to that extent, the ambit of the provision can have to be seen whether it covers or not. And in most cases, Dr. Mozika, you know very well, as far as the Section 37 is concerned, the courts, the hand of the courts are tight.
My lord, why I'm submitting, my lord? My lord, I appreciate,
you know very well.
I appreciate, my lord, Section 37 is there if it is commercial quantity. I appreciate that. Here, my only mitigating circumstance that, my lord, these are not heroin or something like. These are all. One is fentanyl, my lord.
Let him prove.
They themselves are saying it's a fentanyl bottle, my lord.
Yes, the content is codeine. We are talking.
What is the stage of the investigation?
It's a fresh case, my lord. It's registered only on 1st of March. And my lord, we were granted bail by the trial court, my lord, interim bail. And on the date of final hearing, only on some submission by the APP, that also I don't know on what basis, that we have not cooperated with the investigation. Whereas we reported to the IO, my lord.
To add on to that, Lordship, that even in the last occasion, this Honorable Court was kind enough to give them interim. They did not cooperate. That is my instruction from the IO. He was here yesterday. This is the second time they are violating the condition.
We'll allow some more time for the investigation to be completed. I'll go through the CD first.
But my only prayer, Lordship will examine, because there are 3 accused from whose position it was found. So if there is a CDR between them, my lord, that will not implicate us, my lord. Only that part, your Lordship, because I don't have access to that, my lord. Lordship can examine.
Like I said, I'll go through the CD and see your complicity in it.
Deeply.
Item number 4.
May it please your Lordship. Lordship, conducting counsel is appearing through VC. She's finding some difficulty connecting. Lordship, I'm praying if this matter may be placed at the end of the board. 4, 5, and 6, Lordship, are connected.
Okay.
Highly obliged, Lordship.
Daily cost list, item number 1.
Lordship, here, respondent number 1 and 2 are supposed to file their affidavit. However, your Lordship has made an observation on the last occasion, since unavailability of the proper bench, because they have filed an writ appeal. So your Lordship has made an observation to approach appropriate forum. However, your Lordship, I pray if this matter may be taken up on Monday.
I think we have only one recourse, and that is for the prayer of the respondent,
Yes,
KCDC,
Yes, your Lordship.
for this matter to be taken up by, not by this bench,
Your Lordship.
so to say. In that case, we are stuck. We don't know. You see, when will the appropriate bench
Your
be
Lordship.
constituted or will be in place? It may, like I said, it may be today, tomorrow, 1 year, 2 years. So
This is just prolonging the matter, your Lordship. If
exactly.
Lordship, the maintainability of the writ petition is under challenged.
that has already been disposed.
That issue has already been decided,
Lordship, and that order is
and that has been challenged.
Before the division bench.
Came back. As the petitioner, I think it's incumbent upon you to to look at other alternatives.
Your Lordship.
Either you approach the apex court or otherwise, but we cannot just keep the matter lying.
Your Lordship. But if I may humbly pray, Your Lordship, if this matter may be taken up on Monday,
Even
my
if it's
senior
taken up
was
Monday,
surprised.
we'll come up with the same,
My
same
senior will
conclusion.
be there, Your Lordship, on Monday.
Not change the situation a lot of today's.
Your senior or you makes no difference. You are standing there. You are competent enough. On prayer made by the parties, let's this matter up to 4 weeks.
Much obliged.
Item number 2.
This is that matter, my lord, where I tried to look for some authority, my lord. What is the way out in this kind of circumstance, my lord? But I could not get any precision, my lord.
What do we do, Mr. Muzika?
One respondent is represented, my lord, respondent number 3.
Yes. But can the respondent number 3 stand instead of the other respondent?
Others he cannot, but for himself he is standing, my lord.
Yes, of course. And
But my
is your
only concern, my lord, the trial court
is your prayer directed towards the
for restoration of the entire case, my lord, vis-a-vis the other respondents also, my lord. But the difficulty, my lord, at the High Court level, my lord, the trial court had ample remedies, my lord, for issuing warrants,
Yes.
bailable, non-bailable. But the trial court, rather than adopting that course, my lord, they simply dismissed the complaint itself. But it was not a default on our part that we did not take steps, my lord. Steps were taken for issuance of summons several times, my lord. Summons could not be served. The local police could not serve, could not locate the people, my lord, of Calcutta, of West Bengal police, my lord. My lord,
what is the impugn order?
well, page 49, my lord.
Where is he? 49, 50? From paragraph 4, it jumps to paragraph 8.
But it is the previous page. It is the previous page. There's some mistake in that.
No, not here.
The previous page, my lord. Para 5 is there.
Oh,
Same mistakes happened here. I'm sorry, but. But on the counsel who was appearing, my lord, before the trial court, who was representing ROC, his mother had passed away, my lord, around that time. So on that particular day, he could not appear, my lord, and they're taking stock of his non-appearance as well as the accused not appearing, my lord, in spite of service of summons.
So after the case
Summons,
was
summons was served, my lord.
after the case was dismissed,
My lord.
you have no more recourse to appear before the same court,
That is the whole difficulty, my lord.
because
Only under 482, this Honorable High Court only can restore, my lord. Because the trial court has no power of review, my lord. My lord, in an earlier occasion, I placed earlier also, the then Chief Justice, my lord, in similar circumstances, the order is there, my lord. Justice Mittal, my lord. Chief Justice Mittal. 27/6/2019.
the observation here is that you have to, I mean,
If this Honorable Court direct, we can file an application before the trial court.
but is there a provision for recall?
High Court, under 482, your lordships can pass
No,
this out.
under 482, yes, for ends of justice,
My lord.
that can be done.
So
but
rather than your lordship directly restoring, can direct similarly that we will go and file an application for restoration there, like this was done in this case, my lord. So we'll again.
yes, you don't think
I'm appearing only for respondent number 3.
so you
Your Lordship, we may be given time so we can file one judgment. Without the appearance of other accused, the matter cannot be restored. Some time may be
No,
given.
matter we are not asking for restoration, my lord. We are only asking for a leave, my lord, to file an application before the trial court.
Still, you know, we
That
want
will
to
try
file
to serve
some
again through warrant or
judgment,
whatever.
Your Lordship. Because in the impugned order also, Your Lordship, the Honorable
But how
Court
the
below
respondent-
has mentioned that accused number 3 is appearing. After looking at this also, still the matter has been dismissed, Your Lordship.
this was only not on your default.
Yes, Your Lordship, but he has
dismiss-
not found, that's why he has not, he has dismissed, Your Lordship. So we will file some judgment, Your Lordship.
But this is a wrong submission on part of respondent. Respondent number 3 is represented, my lord. Is respondent number 3 representing? That means, or why the holding brief for the other response, my lord?
No,
Either
Your
those have said
Lordship,
that
it's
yes.
not mentioned anywhere, Your Lordship. We are representing for ourselves, only respondent number 3.
Yes, when respondent number 3 is represented, how respondent number 3 can
Why
plead
would
on
you
behalf
be?
of other respondents, my lord?
How would it affect you if the matter proceeds?
That's why,
You
Your
have to
Lordship,
you have to make out your own case.
Your Lordship, we will submit the judgment and if required some pleading also, Your Lordship. So some time may be given for that.
As far as respondent number 3, because the difficulties, case cannot be restored only against respondent number 3. Respondent number 3 otherwise represented can easily be restored only against respondent 3, my lord.
In essence, excuse me.
My lord, one opportunity will be given.
Having difficulty with my cough and my BP is slightly high today. So there's a slight dizziness, made more acute by the confusion created by the lawyers. Mr. Dr. N. Musika, Leonard, DSGI, has submitted that in spite of repeated efforts to ascertain the correct and proper address of the respondent.
1, 2, 4 and 5. 1, 2, 4 and 5.
1, 2, 4 and 5. No fruitful outcome has emerged. However, maintaining that the dismissal of the case before the trial court would highly prejudice the petitioner, it is submitted that one more effort may be allowed to be made by the petitioner in this regard. Ms. M. Hunter, and the counsel appearing for the respondent number 3, has submitted that the respondent may be allowed to submit before this court as regard the situation where and if the presence of the other co-respondent could not be affected and the results thereof. It is therefore, in this regard, it is prayed that the respondent number 3 may be allowed to produce relevant authorities to substantiate this contention. Next. Keeping in mind the issue involved, this court is accordingly persuaded to allow firstly, the prayer of the petitioner to make another attempt at issuance of notice upon the said respondents, and also for the respondent 3 to produce the said authority to be considered if and when necessary. How long? 3 weeks. As prayed for, this is matter to 3 weeks.
Gotcha. Item number 4.
State has filed an affidavit in this case, 1 to 5.
I have filed my affidavit in opposition.
Lordship, on behalf of respondent number 6, I have not completed the affidavit. Lordship. Can we grant 2 weeks time?
You have filed your affidavit? The state respondent has filed the counter affidavit. However, Mr. Isnoklau, learned counsel appearing for the respondent 6, has made a prayer for the counter affidavit to be filed in the course of the next date fixed, as the same could not be filed today. As prayed for, list this matter after 2 weeks. 2 weeks.
In the meantime, I'll file rejoint also.
File, you can file it. That's always allowed.
Item number 6.
Please, Lordship. Lordship, this matter, Lordship, the respondent number 2 is a complainant, Lordship. And he has filed this complaint in his official capacity, Lordship. And yesterday he met me. So now, Lordship, I'll appear for the respondent number 2 also. The notice was issued.
What is this case about?
You're coming for the setting aside and quashing of the entire proceedings, Your Lordship.
No, what are the facts of the case?
Lordship, in this case, the FIR was filed by the respondent number 2, Lordship, on the information received from one of the lady who is staying in the same building with the victim girl, Lordship. The allegation the FIR is that there was a child labor and harassment to the victim. So this complainant, he is a labor inspector, Lordship. He has filed this FIR also in that capacity. So now the child, Lordship, she is from a village, and the parents sent her to Shillong for going to school to stay with the petitioner number 1. But the allegation is that he never sent her to school, and he made her to walk in the house, and also harassment. So the lady who is staying in the same building, she gave the information to the complainant. So that is the case, Lordship. It is not a POXO case, but only for child labor and harassment. The allegation is that he beat up the victim child. That is the case.
Where is this?
Now this is a joint petition, Lordship.
Statement of the victim.
The statement, Lordship, is there. This is a joint petition, Lordship, filed by the accused and the parents. Victim is at page 35. Statement of the victim under section 164. Page 65, Lordship. Or 35.
161 is at 32.
No, this is 161 is a charge sheet. One sixty one in page 47, I think. Not.
Under section 161.
Page 35.
Page 35 is the 164 statement. I'll read out.
Yes.
Name Miss so-and-so. Presently, I am staying with I am a student. I am studying in class 3 at Hongra Para LP and Secondary School, Bernihan. Since birth, I was staying with my parents. However, recently, one auntie whom I used to call Auntie Rina came to our village to pick me up with the permission of my parents with the intention to send me to school. Auntie Rina brought me to Shillong and she dropped me to the house of Shri Precious D. Shira, where his wife Dangchi along with 2 other girls are also staying with him. I do not know the name of the place where I was staying with the uncle. Since that day, I started staying with the uncle Precious. Although my uncle Precious took admission in school, for me, but he never sent me to school. I had never been to school when I stayed in Shillong. Since the time of my stay in uncle's place till the time I left, he used to teach me books at home, and sometimes he used to make me do the household work. The other two girls are grown up and they also used to do the work at home. Uncle wife never made me to do the household work, but uncle does. Uncle used to beat me every day, only when I could not study well. When he beats me, he would use a thick stick to beat me on my hands and legs, and he would hit me hard with that stick. Uncle Precious also cut my hair with a machine, as he said that I was not paying attention during the time he was teaching me. Uncle's wife never say anything to uncle, even when she sees him beating me. One day, one Khasi lady took me to the hospital as there were bruises on my hands and legs which were caused due to the beating of my uncle. I was admitted in the hospital. My parents then came to take me back home after my discharge from the hospital, and since then I have been staying with my parents. That is all I have to say. Allegation is serious, but they have allegation is serious, Your Lordship, but they have executed a compromise agreement, the parents and the accused. It is at page 13.
The parents and the accused may have compromised.
Yes.
But we are looking at the primary person whose interest or whose welfare is concerned. What are the allegations? What are the relevant sections?
Sections. Section under 326 IPC read with section 75 of JJ Act.
What does 75 says? Where is the compromise deed?
Compromise deed. Page 13, Lordship.
30?
13.
Next to Your Lordship. page 13, Your Lordship.
Mr. Moving here. You wish to submit?
Lordship, this matter can come up next day.
Why not? The respondents are
Represented.
represented now.
My lord, because the injuries, my lord, they are not serious in nature. Here, what has happened, my lord? Actually, the victim is the relative of the accused person, my lord. So it so happened like she was under the care and supervision of the accused person. And one day, what happened? This due to some mischief, she was beaten. She was beaten up, my lord. Beat up in a sense like disciplined the child, but it was later on what has happened, what has transpired was that the neighbor has filed a complaint against the accused person.
Yes.
And the parents also was called once the FIR was not once the complaint was made, and the parents actually they did not want to file a complaint against the accused person because he's the relative of the victim as well as for the parents, my lord. And from the medical report also, my lord, it can be transpired that the injuries are not serious in nature, my lord. Actually, I'm relying on the...
Where's the medical report?
Page 44.
It's page 44, my lord.
Your Lordship may produce the medical report. Page 44 is the medical report. It starts from 43, but the relevant portion is 44. All contusions, swellings, and
these are all
abrasions.
Aberration, contusion, and hematoma, my lord. These are all simple injuries, my lord. Lordship, I'm just praying that if this matter can be taken up after 2 days or tomorrow, because I'm relying on the book by Modi, my lord. It's a medical jurisprudence which has been relied up by Supreme Court judges also, my lord. So if I can just be allowed to rely on that particular book also. And I'm actually not prepared with the rulings, my lord, so as to assess this honorable court. If this matter can be taken up on Monday itself also, I can...
Heard Mr. H. Harmi, the additional PP, who has submitted that the respondent number 2, being a public official and who has he filed the FIR in his capacity as labor inspector.
Yes, yes.
Labor
Yes,
inspector.
it is his designation is given.
And who has filed the FIR in his official capacity as labor inspector. Therefore, he is accordingly represented by the said council, by the said additional PP. Mr. AG Movement and counsel for the petitioner has, however, submitted that this matter may be posted for hearing on the next date, as he is not prepared to be heard on the matter today. As prayed for, same is allowed. This is matter on date on 3. This is matter on 3rd. So Monday.
Hello, Monday.
Item number 7.
So where were we?
But here we were supposed to file the written argument, my lord, both the parties. My lord, does me also almost it's ready, my lord. Only thing is that as far as the distinguishing the judgment is concerned, my lord, only that part is left.
You have filed yours?
No, Lordship. Lordship, it's almost ready as well, Lordship. I'm praying for some more time. Lordship, apart from the written arguments that are supposed to be filed, there's a slight bit of reply from our side in terms of the doctrine of proportionality, Lordship.
Then the counsel for the parties have submitted that the written argument is not yet ready, and some more time is sought for the same to be filed. Praise the Lord. This is matter of 1 week.
Malus, may be 2 weeks, Malus, because I'm a little handicapped. Malus, Miss Datta was assisting me, is down with some medical condition for a while. That is why we could not complete it.
You have an able assistant with you.
We'll make an effort, Malus. She was handling the matter, that's why I was making a play. Let them. We'll make an effort. We'll make an effort.
Okay, we'll keep it 1 week. If you can't, then perhaps.
Balance.
Otherwise, keeping it 2 weeks, then if you can't, then another 2 weeks goes.
I
in this way.
2000. In this case, you know that means I will not be filing because yes.
Union did not have too much of a role.
Because I don't think your presence is also required here. It's mostly a policy matter between the state and the petitioners.
All right.
This is matter of 1 week.
Item number 8.
Sonia. You have to place instructions.
Yes.
Lord, this is that matter.
Excuse me.
Lordship, this is the matter regarding that appointment of a teacher in this deficit school, Lordship.
Yes.
Here, Lordship, the respondent number 9 was recommended for appointment. Lordship, this is a very strange case, Lordship. At the time of selection, recommendation and appointment, the respondent number 9 did not possess the requisite educational qualification.
And thereafter she...
But the department recommended her appointment.
On condition that she
will
qualifies.
obtain the requisite qualification within 3 years. That is BEd. The petitioner, Lordship, she had the requisite qualification. She was graduate BEd. But she scored less mark in the examination selection.
The petitioner?
The petitioner. She had the qualification, graduate and BEd, as per the NCTE norms, Lordship. But she did not do well in the selection.
So the respondent 9 was eventually selected.
Selected for appointment with the condition that she'll obtain the BA degree in 3 years.
So the issue would be only on the point of whether the not having the requisite degree would disqualify her, or in the light of what has been stated in the appointment order, that she is to get her degree in due course, maybe that could overcome the fact that she did not have qualified, she did not have a proper degree.
At the time of the selection, Lordship, she did not. She was not qualified.
Exactly.
And how that department passed that appointment order also, with that condition, I don't know how. With the condition, Lordship.
Somebody who's appearing for the state,
Lord,
is
no, my lord,
questioning the order of the state.
my lord, this is a matter. This is a matter whether, my lord, whether law has been followed or not, my lord.
Exactly.
My lord, a similar matter is also pending before another bench, my lord. The Honorable Court, of course, today I don't have the order, my lord. The Honorable Court has directed, my lord, that necessary steps for correction of the error will have to be taken by the respondents, my lord. So, my lord, it's a natural thing. My lord, when the law requires that you required to have, my lord, otherwise, even assuming, my lord, the 3 years term is given for completion of the BA degree, my lord, why would the condition come? The condition came for the very matter that this qualification is mandatory. Now, the department by no stretch could have gone ahead and given so much leverage to the respondent here, my lord. So here in the writ petition, there are several other grounds that we are challenging. We are also challenging that the whole process lacks transparency, my lord, favoritism, nepotism, my lord, because the post had fell vacant in the month of October 2014. My lord, it was the requirement of managing committee to immediately advertise the post. That was never done. My lord, subsequently, when, my lord, the events are in such a way that like today there is a wedding in the family, and the family of the secretary, we have stated all that, my lord. Next day the post is advertised, the daughter-in-law participates, my lord. Then it is only natural how how she obtained so much marks. She is participated, her process is, my lord, it's a very fast process. Immediately interview is taken, she is allotted maximum marks, she is selected, she does not have the B.Ed qualification. Nevertheless, government ends up giving approval. Now, my lord, in the advertisement, all these things, facts I could not have known earlier. My lord, even in the advertisement, they have never mentioned a word stating that this is an advertisement for a deficit school teacher. So even the advertisement were manipulated to that extent, my lord. That is exactly why this Honorable Court, when on date of the motion itself, my lord, found it a fit case to stay the my lord, the appointment of the private respondent.
Oh, the appointment was stayed?
Yes, my lord. Immediately stayed, my lord. This is a high amount of illegality. And my lord, can the government, my lord, go back on its own instructions, my lord? It is my lord, the instruction, what does it say? That it is a mandatory. My lord, it is not that may. It is mandatory. It's clear.
Sorry to interject, but if we are taking up the hearing rather than going piecemeal, if my learned friend starts with the matter, then it would be rather easier for
my lord, in fact, in the earlier round, we had already, matter was part hard. And my lord,
and if my learned friend is completed, we can start.
My lord, if it is required, I'll refresh the Honorable Court.
Yes,
Yes.
it's good to you. So that will be.
We're not going piecemeal,
Exactly,
No, it's not a
Otherwise,
question.
yes.
Firstly, my lord, the managing committee has not even filed their affidavit. My lord, they have nothing on record. They have not refuted any.
Whatever the case may be, you see, you will urge on a point of law.
My lord.
You see,
So first,
most probably.
Yes. First thing is, my lord, whether appointment could have been issued without the B.Ed degree qualification. My respectful submission, answer is no, my lord. It could not have been issued. Whether that any such leverage could have been granted to the private respondent that you complete so and so qualification within 3 years, and then, my lord, and on that account your approval is granted, even that is incorrect, my lord. Now, my lord, because I started
my first leg of argument is that, my lord, she does not have the requisite qualification to be appointed. So therefore, my lord, may I
Anyway,
draw?
you go chronologically.
So, my lord.
Please, sir.
So, my lord, it started with my lord. There was a vacancy, my lord, which had arisen due to the, my lord, death of a teacher in the said Rajabala High Secondary Deficit School, my lord. So this, my lord, this vacancy had arisen in the month of October 2014, my lord. So thereafter, my lord,
So we can see
in the month of October 2014, my lord.
post advertised on.
And my lord, the post was advertised in Shillong Times, my lord, which is at annexure 1, my lord. It was advertised on 6/1/2015, my lord.
Annexure.
My lord, this is annexure 1, my lord, page 19 and page 20, my lord.
Issued on 5/1/2015 by the
So, my lord, the language of the advertisement, my lord.
Yes.
Lord, this is at page 19. Lord, this is a. This is from the extract copy of the Shillong Times, my lord. My lord, it says application in standard form. I have ticked that part, my lord.
Yes, yes.
Application in standard form are invited for the post of assistant teacher of arts at Rajabala High Secondary School. Although it does not say deficit school. Candidate must be arts with major in Assamese, subject with consistently good academic record. Age limit 27 years. Application with all certificates, mark sheets, testimonials, and so and so must reach the school before so and so. My lord, pursuant to the advertisement, my lord, along with the other candidates, as well as the private respondent number 9 and the petitioner herself, had applied for the said post, my lord. Now, my lord, in the said post, nowhere it was mentioned, my lord, in the advertisement,
Yes.
that there would be a written examination. So, my lord, thereafter, when she received the call letter, she had gone, my lord, appeared, and then later on, my lord, it was found that they have to, all the candidates will have to sit for the written examination. So, my lord, they have set for the written examination, and thereafter they have also set for the interview, my lord. So thereafter, after the interview, my lord, the private respondent number, my lord, 9 was appointed, my lord. So thereafter, my lord, I filed an RTI. I got certain informations, my lord, and whether the private respondent had the requisite qualification. With all these information, thereafter, my lord, I found that there is something which is not fair, not transparent with the selection process, my lord. Inasmuch as the private candidate, in spite of having the not having the requisite qualification, has been given appointment.
Excuse me. Yes.
So accordingly, I approached this honorable court by this writ petition. And my lord, the stay was immediately granted by this honorable court on the ground that this is complete violation of the NCT norms, my lord, and the government directions. So, my lord, may I draw my lord's attention how this whole thing happened, my lord. So, as far as my RTIs are concerned, my lord, it is stated. So, these are the informations, my lord, I had sought from the department, which is at my lord, page 9 of the writ petition I have stated, my lord. So, these were the informations which were sought. Page 9 of the writ petition, my lord.
Yes.
So, my lord, copy of the list of candidates, the copy of the final sheet, copy of the guidelines for appointment of assistant teacher in secondary school, copy of forwarding letter of DSCO, because copy of approval letter, list of board members, etc. So, accordingly, my lord, these information were supplied. My lord, in para 8 we have stated, my lord, that para 8 which is at para 10, that after the RTI, my lord, page 10, para 8 of the writ petition, my lord.
Yes.
My lord, here I have stated, my lord. So, if I'm allowed to read, my lord.
Please.
That the petitioner states that after going through the aforesaid reply of the RTIs, the petitioner came to learn that the private respondent number 9, Srimati Jasmeet Jahir, was appointed as assistant teacher, wide resolution of the school managing committee dated so and so, issued by respondent number 8, and the proposal on being forwarded to respondent number 6, DACO, dated so and so, respondent number 5, to respondent number 5 was also approved by the office of the Director of School Education and Literacy, Meghalaya, Shillong, filed later dated so and so. In complete violation of the directions issued by the Government of Meghalaya with regard to the appointment of the said deficit school teacher, which clearly prescribes for B.Ed qualification of the teacher candidates issued by the Inspector of Schools, West Garo Hills, Tura, in pursuance to the directions issued by the Director of Higher and Technical Education and Literacy, wide letter dated 12/1/2007, and also against NCTE as well as prescribed NCT regulations as well as prescribed in Schedule 2, Rule 4 of the Meghalaya School. Anyway, this is as far as the government regulations, my lord, which specifically prescribes for B.Ed qualification degree for assistant teachers of SS, HSS, secondary basic schools, my lord. The relevant contents of the said letter are reproduced herein, my lord. So, my lord, may I take my lord's attention to that letter of the department, my lord. My lord will find this at Annexure 59, my lord.
Annexure?
Annexure 59. Apologies, my lord. Annexure C1, page 59, my lord. If I am allowed to read, my lord.
Yes.
Please find herewith the copy of letter dated 12/1/2007 received from the Director of Higher and Technical Education, Meghalaya, Shillong, regarding appointment of assistant teachers in deficit secondary schools for favor of your necessary action. In this connection, I am to say that while appointing the assistant teachers in any vacant post at deficit secondary schools, the candidate selected for the appointment to the post of assistant teachers should be graduate with B.Ed degree holder, failing to comply with the above instructions, no approval. So, my lord, this itself is very clear. No approval for appointment will be accorded from the concerned authority. Further, the appointment against the B.Ed deputation vacancies, even the deputation, even the vacancies which are on deputation, my lord, even those vacancies should also be made with candidates with B.Ed degree holders. This shall come into force with immediate effect. Now, this came into force in the year 2007. My lord, the subsequent letter, because this is only reiterating what the stand of the government is. Even the subsequent letter, my lord, which is at the next page, page 60.
Page 60.
Page 60, my lord.
Yes.
In fact, this was the letter which had come earlier, and
Yes.
the other letter is only a reiteration, my lord. On the subject, so this is what came from the Director of Higher and Technical Education, my lord.
Yes.
And subject is what? Appointment of assistant teachers in deficit secondary schools. On the subject cited above, I am to state that for the improvement of the quality of education, it is desired to implement the NCTE standing guidelines which are mandatory. My lord, may kindly see the language.
Yes.
Which are mandatory, which prescribe that all the teachers at secondary level are to be it's not maybe, my lord, are to be graduate with B.Ed. As such, you are hereby informed to ensure all vacancies in deficit secondary school should be filled up by B.Ed degree holder. Failing which, so my lord, it's the same thing. Failing which, no approval should be accorded from this office or your office. This shall come into force with immediate effect. So, my lord, this itself shows, my lord, the order of approval which is granted by the government, my lord, giving leverage to the private respondent. And my lord, so my friend has, my lord, thanks to my friend, is assisting me in this case, my lord. My lord, with regard to the other matter which I had, my lord, at the beginning brought up before this honorable court, this is that matter, my lord. This is that matter, my lord. It is WPC 480 of 2021. This is Pompa Viswas versus State of Meghalaya, my lord. So, my lord, there the government has already taken that stand, my lord, that this could not have been done. So, my lord, in one case they cannot say this, and one. So,
You're just.
So I'll
You're
produce
just
the record.
relaying information.
My lord, I'll produce
off the cuff.
I'll produce the record, my lord. So, my lord, but even from the record here, but it's clearly evident, my lord. My lord, the which clearly shows that the government could not have issued this appointment order at all.
Okay.
So it deserves to be struck down immediately, my lord. There is no merit. My lord, no such leverage could have been granted to the petitioner, my lord. Now further, my lord, my lord, may I take my lord's attention to again to my pleadings, my lord, which is at page 11 of my writ petition, my lord.
Yes, page 11.
My lord, may I read, my lord? Yes. It is further stated that the hurriedness showed by the respondent authorities and the chronology of events starting from the nature of the advertisement. My lord, nature of the advertisement, because the advertisement was made with the very idea, with the very intention to suit the private respondent. So, my lord, there is no fairness at all, right from the beginning, the inception, because, my lord, the private respondent was the daughter-in-law of the then secretary. So, it was a clear intention. The whole thing was designed so that she can be appointed. So, my lord, if it is further stated that the hurriedness showed by the respondent authorities and the chronology of events starting from the nature of the advertisement dated 5/1/2015 published in the Ceylon Times dated 6/1/2015, call letter dated 19/1/2015, interview and result sheet dated 20/1/2015, resolution of the school managing committee, Rajabala Deficit Higher Secondary School dated 21/1/2015, in selecting the private respondent number 9 as the assistant teacher of the said school, and the approval letter dated 21/3/2015, granting approval to the respondent number. My lord, there's a typographical error. Oh, no, it is okay, my lord. Granting approval by respondent number 5 against and contrary to the directions of the government dated 12/1/2007 and NCT regulations, etc. to the appointment, it should have been, my lord, of the private respondent number 9, indicates as if the school managing committee or the authorities had already made up their mind to appoint the said private respondent in the post of assistant teacher Rajabala Higher Secondary School. It is equally surprising that the approval letter issued by respondent number 5 in favor of respondent number 9 states that the appointment of the private respondent number 9 is approved on the condition that she should complete B.Ed within a period of 3 years, which is highly questionable. Whereas the petitioner, in spite of having the B.Ed degree qualification, has of the students, and hence the same ought to have been taken into consideration while selecting the candidate. My lord, again, my lord, if I take draw my lord's attention to, my lord, the next page, page 12, my lord, the sub-para, my lord. Again, if I may read, my lord, again in the final result sheet dated 21/2015, Annexure 14 of the writ petition, the basis and the manner in which marks have been allotted to private respondent number 9 at serial number 3 deserves strict scrutiny of this honorable court. As far as the teaching experience of the private respondent number 9 is concerned, the same also appears to be false and untrue, as because firstly, the experience certificate of private respondent number 9 nowhere mentions that the said private respondent was serving as a teacher, and secondly, even assuming that the said respondent had been employed as a teacher since the year 2009, in that case, the private respondent number 9 ought to have been employed since her matriculation. So, my lord, immediately after matriculation, she started teaching, which perhaps could not have been the case. The petitioner, on the other hand, who is shown at serial number 7 of the final result sheet, although having 2 years of teaching experience, was not allotted any marks for her teaching experience, to which she is rightfully entitled. However, it may be stated that the petitioner is placed second. So, my lord, comparing the marks, the only other person who is qualifying, my lord, other than the private respondent, is the petitioner, my lord, is placed second position in as per the final score sheet, result sheet, and also has B.Ed degree qualification as per the directions of the government of Meghalaya, and hence the petitioner rightfully deserves to be appointed as assistant teacher arts against the said vacant post. So this is my prayer, my lord. Now subsequently in para 10, I have again stated, my lord. So here I have raised question even about regarding the advertisement, my lord. That the petitioner states that from the given circumstances, it appears as if the advertisement dated 5/1/2015, in other words 6/1/2015. This is the next page, my lord, page 13, yes. Para 10, was perhaps issued in order to suit the qualifications of the private respondent number 9. Even if it is assumed that the said advertisement was to fill the vacant post of Assamese teacher in the said school, it may however be stated that the interview board constituted wide memo so and so appears to have been constituted for assistant teacher arts alone. Although here they don't mention any language. In the advertisement, special emphasis is given on Assamese language. Why? Because the private respondent has that qualification alone, and there is no mention about Assamese teacher. Again, the appointment order dated 21/1/2015 mentions only assistant teacher arts in Rajabala Secondary School. So, these are the kind of manipulations which had taken place. So, my lord, these were the illegalities, and therefore, my lord, the petitioner, having the requisite qualification, was expecting that she will be considered for the post. But what had happened was that, because, my lord, what we came to understand is that this whole process of appointment was, my lord, in my respectful submission, was only to, my lord, give benefit to one person, my lord. So, my lord, now that is highly unjustified. Then why have selection process at all? If there is a predetermined mind, preconceived plan that so and so person will be, my lord, appointed, then why unnecessarily have the selection process? By this selection process, you are giving hope to all the others. Now, all the other citizens, eligible citizens, have a fair chance to participate, and, my lord, for the expect an appointment, so that they can, my lord, better their life, their lifestyle, job security, etc. Now, my lord, if so much of leverage is granted to one candidate, my lord, what will the other people do? Where will they go, my lord? So, my lord, in my respectful submission, my lord, on this account, my lord, firstly, my lord, the respondent authorities should have, my lord, not given approval, especially the state, my lord, should have not or could not have given approval to the petitioner on the very account that this is against the laid down norms and procedures and the law, my lord. And I should have been considered. On the other hand, my lord, in spite of, as far as the, my lord, after my friends submit, later on I might give a rejoinder. Even in the score sheet, if my lord goes to the score sheet also, my lord, I have not been allotted any marks for even for B.Ed degree. The petition, why is it so? So, my lord, my respectful submission.
Is
my
the
lord,
score sheet here?
Score sheet is here, my lord. My lord, kindly bears with me.
Page 112.
Yes, my lord. What will kindly see this, the private respondent is at serial number 3, and my lord, I am at serial number 7.
Yes.
So, my lord, her all qualifications 10 marks. My lord, I have been given 555. Teaching experience, I have been not given any marks. Private respondent has given 10 marks full. So that means immediately after matriculation she started teaching. So she has already gathered a great deal of experience. So she got 10 marks. My lord, there is no mention for marks for B.Ed. You have, and my lord, whether this kind of score sheet, the kind of score sheet, whether this is the pattern in which, my lord, the marks ought to be given. Because as far as we understand, my lord, whether it conforms to any specific pattern of marking. So, although that's another issue, my lord. So, my respectful submission, my lord, the private respondent has had all the benefits, my lord, that could have been given to her, all leverage that could have been given to her, and that cannot be allowed, my lord. Because my first thing, my lord, even going into all these facts, even assuming that nothing else is there, even assuming that everything else is incorrect, my lord,
Yes.
even disregarding all my other submissions, my lord, the first point, the first hurdle, my lord, whether she could have been considered without the requisite qualification, my answer is no, my lord. Whether the approval could have been given, that sort of condition could have been granted to the private respondent, my respectful submission, my lord, is no. No such leverage could have been granted. So, my lord, these orders deserves to be, my lord, set aside in question, my lord. So, my other friends may submit, my lord, if required. And as far as the rulings are concerned, my lord, although some of the rulings I don't have it today, my lord, at any subsequent date, my lord, whether if I am told to file a written argument, I am ready to do that, as well as the rulings, my lord.
Yes, you can do that.
My lord, even in fact, just one more minute, my lord. I've also come across certain Supreme Court decisions, my lord, where, my lord, now whether, my lord, if it is a question whether it, I am saying that her appointment order should be quashed and I should be reinstated, my lord. Now, if it is argued that the whole, my lord, proceeding has to be quashed, my lord, I also have some certain Supreme Court judgments where, my lord, Supreme Court has held that there are times you need not quash the whole proceeding, but the deserving candidate may be appointed, my lord. But anyway, that at a later stage, my lord. Let my friends submit.
Yes, who will go first? Advertisement was issued by the managing committee.
One managing committee secretary.
So, Mr. Paul?
I'll start.
Okay.
My lord, before my friend starts, my lord will kindly keep in mind, my lord, the managing committee has not refuted anything.
I don't need to refute anything, my lords. I'll go simply by the records that my learned friend has placed in the writ petition. It's not a question of him saying yes and me saying no. I will go by his documents.
Yes, records will be recorded.
The government instructions are there and also the NCT norm.
I will go only as per the records, my lords. What my learned friend has referred at the writ petition, I'll go to that. Because from what I can gather from what...
You are respondent?
Well, just bear with me for a second. I am the principal who's at respondent number 7, my lords, and then I'll be respondent number 8. Substituted respondent number 8, because you substituted the new managing committee, right? 7 and 8.
Okay.
Well, it's from what I can gather from my learned friend, his arguments are basically on twofold. A, that the advertisement itself was incorrect in terms of the NCT letter, those letters by the director. And, my lords, there is a second limb of his argument which says that the entire process was vitiated because the relevant marks that were required to be given to my learned friend's client, that is the petitioner, was not given, and I was, the respondent number 9 was unduly favoured. That is the case as far as I can understand. Because I'll first take your lordships to the prayer in the writ petition. Your lordships may first see what is the prayer that my friend is asking for. Your lordships would find that at page 16 of the writ petition. Your lordships have it, man.
Yes.
Let's just skip the first part. The substantive prayer is quash and set aside the impugned order number so-and-so dated 21/1/2015, appointing the private respondent number 9 as assistant teacher Rajabala Higher Secondary School, Rajabala, approved and approval granted by the Office of the Director of School Education and Literacy by letter number so-and-so dated 23/1/2015, as the same as in the gross violation of the procedure of law and the directions of the government of Meghalaya. So in essence, my lords, the order of appointment and the approval thereof granted by the state, my lords, has been challenged by my learned friend. Now, the first limb of the arguments made by my learned friend is that the advertisement was flawed. I question myself, my lords, where is there a challenge to the advertisement in the first place? Your lordships would see that the advertisement was made on originally by us on 5/1/2015, published in the newspaper on 6/1/2015. The petitioner chooses to participate in that proceedings. Petitioner does not come before this honorable court or go before the government at that stage and says that no, this advertisement is flawed because it is against government instruction. So in terms of what your lordships have held in Chandrasekharan, my lords, he categorically takes a chance.
Yes.
The petitioner takes a chance. Said, if I sail through, it is done. I need not challenge the advertisement. Now, since my grapes have turned sour and I have failed in the selection process, I come back and choose where I can find instances of challenging the advertisements itself. And even though submissions are made before your lordships with regard to the fallacy, if I may say, in the advertisement, that is not put to challenge before your lordships. So if the advertisement is not challenged, The petitioner participates in that advertisement, takes her chances. And then when she does not qualify, my lords, comes and says that the order which is the sum total of the entire process of selection emanating from the advertisement, it is flawed because the advertisement was incorrect. So I ask myself a question, my lords, whether that is permissible in law. Your lordships in series of judgments, starting from Chandrasekharan, my lords, have said, once you've participated in the process, you've taken your chances, your grapes have turned sour after you failed, sorry, we will not entertain you on that ground. So to that extent, my lords, I think the challenge of my learned friend would come to an end there. Now comes to the second limb of his entire argument, my lords, he makes a statement, my lords, that the advertisement itself was custom made for the private respondent number 8. Then again, my lords, the question arises, did you challenge the advertisement? No. As a matter of fact, what the petitioner does, my lords, I'll just take your lordships that how this entire case comes about being. If your lordships kindly have Annexure 2, page 21, that is the application made by the writ petitioner before the managing committee, insofar as in support of her candidature.
Page 21.
Yes, my lords. Very interestingly worded letter, my lords, if I may read. Your lordships have it, my lords. Yes. May I read? This is, my lords, to the secretary. This is by Sania Sultana Surkar, my lords, and it says, Sir, understanding from your advertisement published in the Shillong Times daily newspaper dated the 6th of January 2015, a post of assistant teacher in your school has fallen vacant. In the resultant vacancy, I, as a local qualified candidate, have applied for the same post. Though in your advertisement, it has been mentioned that preference will be given to candidates having major in Assamese, but I have Assamese combination subjects with B.Ed from NEHU. So my application may also kindly be accepted. Your lordships, the important word, and I harp here, is the word also. Reason being, my lords, I will take your lordships to the advertisement now. Your lordships will kindly see what is the advertisement. Your lordships will find it on the previous page at page 20.
Yes.
It says, my lords, applications in standard form are invited for the post of assistant teacher, Rajabala Higher Secondary School. Candidate must be an arts graduate with major in Assamese. So what is the essential qualification laid out in the advertisement? Your lordships will kindly see. You have to have a major in Assamese. Subject with consistent good academic record, age limit 27 years, applications with all certificates, mark sheets, testimonials, mobile numbers, etc. must reach the Secretary Managing Committee on or before 15/1/2015. So the only essential qualification laid out in the advertisement is you must have major in Assamese. Petitioner is conscious of that fact. So your lordships, at page 21, the petitioner writes a letter to the managing committee, says that even though you have laid out the essential qualification of Assamese being the primary essential qualification, I do not have Assamese as a primary essential qualification. I have had it as a mixed subject. Kindly consider my application. So, my lords, here we must pause and ask ourselves a question. Whether the petitioner on the date of the application was herself educationally or otherwise qualified for the purposes of this particular advertisement. In her own admission, it is no. So if I am not qualified, my lords, at the initial stage, and I am conscious of that fact, I am not qualified, and I make an application that says I am a local candidate, I do not have Assamese as a major, but I have it in my MIL, so kindly consider my case. It is considered. After that, somebody is selected after the due process of selection, whether the petitioner can turn around and say, no, your advertisement was flawed. There were anomalies. There are instances of favoritism, nepotism. My humble submission, my lords, these kind of pleas at this stage cannot be entertained, considering the conduct of the petitioner.
The fact remains that her advertisement was considered.
We considered it.
In spite of lack of
my lords, and which is why I'll take your lordships, why I pointed out the score sheet at 115, that's the reason why I pointed it out. I was conscious of the fact why I'm pointing out 116. Your lordships may kindly come thereafter 107 with 65. Your Lordship, just bear with me for a second, please. Now, the reason, my lords, I would also have to give some kind of justification to your lordships as to why we recommended so and so in the face of that letter, my lords, which was there, because that would be there. And I think it would be also the bounden duty of the government advocate to assist your lordships as to why a panel headed by none other than the inspector of schools accorded approval in this case and said that you go and complete your B.Ed, we'll give you some time. There has to be some reason. Now, your lordships will remember that at page 105, my friend had pointed out these two letters that so that a certain standard of education is maintained, we should engage teachers, graduates with B.Ed degree. Now, your lordships may kindly come to page 65A. There's also the other documents that establish this. This is the application of the respondent number 9, my lords.
Yes.
Why she was considered. Lordships have it, my lords?
Yes, yes.
Column number 9, my lords. I'm sorry, row number 9, my lords. Your lordships will see sub row number 4.
My lord, as far as why she was considered, my lord.
Whereas I don't want to be interjected. I did not interject my friend when
lord,
he said.
He has not filed any affidavit.
I don't need to file an affidavit. I'm relying on your documents.
No, my lord, because he is telling that why she was considered.
Yeah, so
I'm relying on your documents.
Yeah, this is your document. So he's relying on your document.
Well,
So
this
if-
is my
Unless my friend says that these documents are not his.
No, this is the document is there.
Yes.
But the moment he says that this is why they have considered, my lord, then it is the stand of the private the managing committee, my lord.
that would be his argument.
My lord.
You've had your chance. You can reply to it later. Yes.
I'm just placing records before your lordships.
Please continue.
Page 65A, your lordships may kindly see. Row number 9, my lords, serial number 4, your lordships will kindly see. BN College, Dhubri, appeared in MA.
Yes.
The respondent number 9, my lords, at the time of the interview had already appeared for her final year in Masters. And that is also borne out, my lords, from page 57, my lords. This is the statement showing the stature of the candidates insofar as...
She may have appeared in a or whatever.
My lords.
But the fact remains that she's at the relevant point of time.
She was not... She was...
She is just a plain graduate.
Why, my lords, it weighed with the managing committee? I am only saying why it weighed with the managing committee. Whether it was a correct weightage or whether it was not, my lords, that your lordships will decide. I have to only place before your lordships why it weighed with the managing committee. Your lordships may kindly come to page 57 because this is the comparative statement of the parties. 57A, my lords.
Yes.
Your lordships will kindly see. At serial number 3, my lords, is the private respondent.
Yes.
So I'll just give the statement of comparison, my lords, between the petitioner and the private respondent, my lords. Your lordships will see first. SSLC, my lords, she secures a first division. Petitioner secures a second division. Petitioner at serial number 7, my lords.
Yes.
The private respondent gets 63%, my lords. Petitioner gets 55%.
Yes.
HSLC, my lords, private respondent gets 65.2%. The petitioner gets 49.80%.
Mr. Paul, whatever the case may be, these have been considered in this final score sheet.
Lordships. Why? Because why I'm pointing it out, my lords, because I will not want to bother your lordships to take your lordships again to the score sheet to say why she got 5 and why respondent number 9 got 10. The only reason is pointing out this from here, my lords, because one of the submissions that was made by my learned friend before your lordships is that he did not even deserve 1 mark
See,
for B.Ed.
if you look at the score sheet,
Lordships.
there itself it says educational qualification 10 marks for first division.
My lords.
So if you are in first division, then you...
My lords, because it has been argued before your lordships that the entire selection process was flawed with impropriety, nepotism and favoritism.
Perhaps the pro forma may not be in a proper form, but it is there nevertheless.
If your lordships have seen that, my lords, I need not bother your lordships with that. But the fact of the matter remains, my lords, that your lordships will see that under the relative criteria, whether the marks have been properly allotted or not. As long as it has been properly allotted, my lords, I would pray that they would not deserve any interference by your lordships. That's the only reason of pointing out this.
Okay.
And your lordships will kindly see, my lords, as against major and assamese. Now, that was the essential qualification laid out in the advertisement. And assamese, your lordships will see. Page 57, your lordships have it. 1, 2, 3, 4, 5th column, my lords. Major and assamese. On top, your lordships will see.
Yeah.
Major and assamese. Your lordships have this comparative chart that I was...
Yes. Page 57, yes.
Yes. So, it is major and assamese. The heading is major and assamese.
Yes.
Because this was the essential qualification as per the advertisement.
Yes.
And down below your lordships will see. Petitioner does not have any major. That is an admitted position. And that is borne out in the score sheet itself. Now, my lords, if we, considering these facts, if I come back to what my friend has been arguing, that assuming, my lords, let us for one instance forget, my lords, what has happened in that matter. Assuming, my lords, the advertisement was flawed for not having written B.Ed as an essential qualification. Where is the point at which it ought to have been challenged? Not after I have sat for the examination. Not after I make a request to the managing committee that please relax the essential qualifications as stated in your advertisement and allow me to participate in the process. I sit for the written examination, I sit for the viva voice, I take my chances with that selection process, and after all that, my lords, when I'm unsuccessful, I'm here before your lordship saying that no, everything is there. The wolf is between the sheep.
Yes, of course.
And my lords would also kindly see I'll now bother your lordships to again go back to the prayer. I deliberately did not read the second portion of the prayer because I wanted to conclude this part of my argument before I take your lordships to page 18.
Okay.
Now, what is the second prayer my learned friend makes? Your lordships may kindly see the second paragraph. And be further pleased to appoint the petitioner. And may kindly direct the concerned respondent authorities to appoint the petitioner in the post of assistant teacher, Rajabala Higher Secondary School. I say, my lords, the advertisement is flawed. You could not have done it. Selection process is flawed. Everything is flawed. But, my lords, I am still before your lordship saying, oh, I may be appointed. So, my lords, whether before your lordships, the doctrine of approbate and reprobate would come in. If I am blowing hot, my lords, I would have to blow hot and I will have to say the entire procedure has to go. Or if I am blowing hot and cold, my lords, whether your lordships would then entertain this writ petition under Article 226.
Yes.
So far as, my lords, judgments are concerned, my lords, your lordships are already aware of the law in this, my lords, led by Chakradhar and a series of other judgments of this issue. So, otherwise also Chakradhar is the leading authority in so far as, my lords, this aspect of the matter is concerned.
See, as far as the law is concerned, it's well settled. What we look for is only aberrations.
My lords, I am only on that limited aspect, my lords, that once you have participated in the proceedings, you cannot take a U-turn, my lords, and come back and challenge the proceedings.
That is well settled. Until and unless, you see, they can make out a very strong case.
Of aberration from the, my lords, set standards.
Exactly.
Petitioner can challenge, my lord, if a certain law which is supposed to be followed is not followed.
Exactly.
My lord, firstly,
There's
advertisement.
no stopping you.
My
You
lord.
can.
No, I'm not finished. You can give your reply after I'm done. I would not want to interject and make it.
No, because I was under the impression that it's done.
So, Millards, in my humble submission, the second prayer made by the writ petitioner before your lordships itself renders this entire writ petition defective in law. Because this relief otherwise also cannot be granted by your lordships in exercise of power under Article 226. Because there is a selection process. In the selection process, my lords, you are not found suitable. And your lordships are aware, my lords, again the position of law is that this honourable court will not substitute its views insofar as the selection is concerned and grant relief to a petitioner. Because these are matters where your lordships, at the most, your lordships will then say that the entire process has been vitiated, it would have to be set aside.
Exactly.
And you'll set it to naught. So the second
Now,
prayer...
now you're questioning the process of judicial review.
No, I am not questioning the process of judicial review, my lords. I am only reiterating what your lordships have laid down as the law of the land.
Even you know very well, Mr. Paul, I don't have to. In fact, you have to teach me. Not
No, I cannot.
Even facts,
telling you something, my lords, is like showing the light to the sun.
Even you see, facts can be taken up, for consideration under 226.
No, if they are similarly situated, my lords, and your lordships come to record a finding, that she has been, my lords, by extraneous means degraded in that matter, then in that event, your lordships can pass appropriate directions. There is no end to, my lords, the powers to be exercised by your lordships under 226. But, my lords, somebody who having participated, having failed in the examinations, or not qualified, well, I will not say failed, not having qualified or being successful in the examinations, your lordships have consistently held that this court will not substitute its views for the views taken by the selection committee. At the most, your lordships will do away with the entire selection process and say that let it be redone again. So the second prayer of the writ petitioner in any event, my lords, what I am humbly submitting before your lordships, cannot be considered by your lordships. I'll oblige. I don't know what my friends have to say. So. Judgments, my lords, I am only referring to Chakradhar. I'll place a copy of Chakradhar.
And we have the private respondent here.
Private respondent is the one principal.
So should we hear him first and?
You will come. Your number will come since you're supporting.
Because
mine is very short. My submission is also very short. Then, please, Lordship. Lordship, in this matter, Lordship, the entire problem is started from the advertisement, Lordship. The advertisement, it was issued by the Secretary, Lordship, who is not aware of the government instructions and the NCTE norms.
Yes.
And the appointment order should not have been issued. Should not have been issued. It is not in conformity with the...
You have issued the approval.
Yes, Lordship. I fairly submit, Lordship, that it should not have been issued. It is not in conformity with the norms and the government instructions.
Only as far as the qualification is concerned.
Qualification is concerned. As far as qualification is concerned, Lordship. The petitioner had the qualification, but she did not do well in the selection.
Petitioner did not have the qualification because she is not qualified as far as major and ASMIS is concerned.
As per the advertisement, yes, Lordship. The advertisement says that a candidate must be a graduate with major in ASMIS. If we take it from the advertisement, the petitioner is not qualified. The petitioners are not qualified. But if we take it from the norms, NCTE norms, that means the petitioner is qualified.
Only to the extent that she holds a B.Ed degree.
Yes, that is what, Lordship. If we take from the
advertisement, the private respondent.
If we go by the advertisement, Lordship, the petitioner, she is not qualified. The petitioner, she is not qualified. But if we go by the norms, the petitioner is qualified. So here is the case where both the parties, one is having the qualification and another one does not have the qualification. But according to the advertisement, Lordship, she had the qualification.
Yes, please continue.
And Lordship, in my submission is that, Lordship, if your Lordship decide to allow this repetition, Lordship, so my submission is that the selection, entire selection may be scrapped. It can be scrapped, and the selection appointment of the EU be set aside if your Lordship decide to allow this matter.
Yes.
That is my only submission, Lordship.
Mr. Novi?
Lord, as an applicant,
Yes.
I have 4 points, my lord. My lord, the first point is on the advertisement, my lord. Second is on the B.Ed qualification.
Yes.
Third is on the bar by estoppel, my lord, to challenge. And third is there's no challenge to the proceedings itself. So these 4 points, I will just make a very short submission, my lord. My lord, I have responded as an applicant to the advertisement which has been published in the newspaper, my lord. And I will not read the entire advertisement again because it has already been indicated. So as per the advertisement, being qualified, my lord, to take part in the process, I have taken part in the process. That is one, my lord. And the advertisement is not under challenge. The initial step of the process of selection, my lord. Now, my lord, pursuant to my taking part in the selection process, my lord, pursuant to my taking part in the selection process, an interview board was constituted by the office of the DSEO West Garo Hills, which is at page 1. This is last annexure 16. Kindly have that.
Page?
Annexure 16, my lord, page. My copy does not have the page number.
My lord, annexure 16 will be page 114.
This will be page 114, my lord. So, my lord,
Yes.
by this order dated 19th of January 2015, the interview board was constituted. It reads, my lord, the interview board members is hereby constituted with the following members to conduct the interview of assistant teachers arts at Rajbala Deficit School, Higher Secondary School on 20th of January 2015 at 11 a.m. I kindly have the members, my lord. The interview board was chaired by the Joint Director, my lord, of School Education and Literacy. The second member is the DSEO, my lord, of West Garo Hills. The third member is a subject expert, my lord, a teacher. The fourth member is also an educationist who is an independent member, who is a former additional director of school education, and the fourth is the principal. The fifth member is the principal. So the interview board, my lord, was formed by the government. Members also belong to the department. So the allegation of nepotism, my lord, this will answer for itself. My lord, on the basis of this, on the basis of the interview conducted by this board, I was recommended, my lord, for appointment. Now, my lord, at page, at annexure 10, this should be page 100. Page 100, my lord. page 100 is dated 21st of January 2015. This is the proposal submitted by the Office of DSEO, my lord,
Yes.
to the Office of the Director, School Education and Literacy, Meghalaya. So the proposal, my name was proposed for approval by the Office of DSEO to the Office of the Director, my lord. Now, my lord, approval has to be granted by the Director, because the Director is the appointing authority, my lord. Now kindly have the next page, my lord, page 11 of page 101 and extra 11. This is dated 23rd of January 2015. This is the letter issued by the Director of School Education and Literacy to the District School Education Officer, West Garo Hills, my lord. Now it reads, my lord, it reads, with reference to your letter on the subject cited above, I am to inform you that the proposal for School Managing Committee of Rajbala so-and-so for appointment of Srimati so-and-so as assistant teacher in the vacancy caused due to the demise of so-and-so is hereby approved on the condition, there's a rider, my lord, on the condition that she should complete B.Ed within a period of 3 years.
This is the bone of contention.
Correct, my lord. Correct, my lord. Correct. Now, this letter has been issued by the Director. Now, the letters which my learned friend, the petitioner, has relied upon regarding the instructions on the requirement of B.Ed, my lord, will find at page 103, which had already been read by my learned friend, dated 12 January 2007, page 103. Now, these directions for requirement of B.Ed, has been issued by the then Director, my lord, same office.
Yes.
Same office, requiring that henceforth there should be the requirement of B.Ed will be. It reads, my lord.
So Mr. Nongre, the fault committed apparently was within the department. One correspondent, or rather one order, will contradict the other.
Correct, my lord. Correct. But my submission is, this approval is not a complete approval with a rider, with a condition that if she does not obtain B.Ed within 3 years, then this appointment will not stand.
But where is the provision for that? Under the
I will indicate, my lord. I will indicate. Now, the whole reliance of this case is on the 2001 regulations issued by the NCT. Kindly have your lordship at page. Lord, I'm slightly handicapped because the copy which I have does not indicate the page numbers. Page number 106, my lord. So, 2001 regulations, my lord, at page 106.
Yes.
This is the National Council for Teacher Education Determination of Minimum Qualifications for Recruitment of Teachers in School, Regulations 2001. So at that point in time, these regulations were in place, my lord, were governing the field. Kindly have page 107, my lord. Now in the table, in this second last, my lord, row,
yes.
In the table, second last row at number 2, it reads, my lord, secondary/higher school.
Yes.
It's this one or the top one?
Yes.
Yes, my lord. So what do these regulations provide? They provide graduate with bachelors of education, B.Ed, or its equivalent, my lord, or its equivalent. In my humble submission, my lord, MA is an equivalent, my lord. I may be wrong, But it does not say B.Ed only. It says or its equivalent.
No, but
Therefore, my lord,
this term has to be qualified.
my lord,
It has to be qualified subsequently, or within the rules itself.
Exactly.
Pardon, my lord, I didn't
I
get.
said this term has to be qualified. Equivalence mean what? Excuse me. You are saying that equivalent means it could also be MA.
My lord, I am not saying this. The regulations issued by NCTA says this.
Exactly.
Why I am indicating this to your lordship? This is why the director has then given that has provided the rider.
Just a moment, Mister.
That's why he has given a rider in the approval that it will be subject to your completion of B.Ed. Why? Because the regulations are not very clear. If you complete, then you may keep the post. Otherwise, you are out. Now that comes to my second point, my lord. That as on date, within 3 years, I have completed my B.Ed. I hold a B.Ed degree. I have complied with the approval order by the director. Number 3, my lord, the petition, this challenge by the petitioner is barred by estoppel, my lord. Petitioner takes part in the process, at the very first instance does not come, takes a chance, he is unsuccessful, then my lord challenges not even the proceedings, just my appointment letter, not the proceedings. That's my third point, my lord. And my lord, there's a judgment by your lordship on the question of estoppel, my lord, doctrine of estoppel. I was on the receiving end in that case, my lord, so I'll be citing this judgment, my lord. This is, my lord, reported in 2001 SEC Online, Meghalaya, page 75. So in this particular judgment, your lordships have discussed the doctrine of estoppel. And in this particular case, your lordship have said that if you have taken part in the process, even if you have succeeded also, you still cannot come back and challenge.
Like I said, those are well settled principles.
So these are my submissions, my lord. Beyond this, I have no more submissions.
My lord.
Yes.
My lord, firstly, my lord, my lord will kindly see
how long will it take for you to reply? We are already past lunch time. We continue after lunch?
I think my friend will take 5 minutes. Well, it's hardly 5 minutes. We've all concluded our parts.
No, it's after lunch even I have difficulty. I'll try to finish within 5 minutes, my lord. If not,
Lordship, just bears with us for 5 minutes, my lord. I think we'll put an end to this.
If not, my lord, then my lord, it may go on some other date. My lord, firstly, my lord, my lord, kindly see that the advertisement, my lord, how am I supposed to be aware, my lord? My lord, the advertisement nowhere says that this is an advertisement from a deficit school. My lord, plain on a paper, on newspaper, I have seen an advertisement. I have applied. It is not a fact that I was aware that this is a deficit school and these are the required qualifications. I was not even aware. And that is clear by that letter, my lord, which is at annexure 2, page 21. My lord, here the selection process had already started. The result was awaited, my lord. In the meantime, I have issued this letter. What does it say? Understanding from your advertisement published in the Shillong Times daily. My lord, this is annexure 2. I'm just reading it, my lord.
That has been referred to by Mr.
Yes, yes. My lord, here it is nowhere mentioned it's a deficit school. I am not even aware that it's a deficit school. My Lord, when do I come to be aware? My Lord, may kindly see my RTI. When was the RTI filed? Now, my Lord, in the meantime, my Lord, before filing the RTI, my Lord, some way or the other, my Lord, sometimes we hear to see by word of mouth or something that, my Lord, that so and so person perhaps being appointed or whatever. My Lord, so on that account, I had issued a letter also, my Lord. Lecture 2, Lecture 4. My Lord, will kindly see my letter that is 27 January, which is at Lecture 4.
Page?
So this was a complaint which was filed by me.
Page?
My Lord, this is page 53, my Lord.
3. Yes.
So, my Lord, this is where I have filed a complaint, my Lord, saying that by then, my Lord, I have come to know that before my exams, I never knew also. But then, even then, I was not sure, my Lord. So, thereafter, I have filed an RTI. Now, when did I file the RTI, my Lord? My RTI applications are dated. My Lord, my RTI applications. My Lord, the first RTI, my Lord, application is dated, my Lord, dated 27/1/2015. Second RTI, my Lord, is dated 31/3/2015. So, and thereafter, I received the required informations, my Lord. Now, it is not a case, my Lord, it is not a fact that I was fully aware that this is a deficit school, B.Ed degree is required. No, I was not aware. I came to be aware only subsequently. Had I been aware, my Lord, then I would have approached His Honourable God for stalling the selection process itself, my Lord. But that is beyond my scope. It is already gone. I have come to know only when my Lord, when everything is over. That is when, and my Lord I may draw my Lord's attention to another aspect. My Lord, the post which had fallen vacant, my Lord. So that is the GI form, my Lord, which is at annexure 15, page 113, my Lord. So all these things I was not even aware. I am an outsider, my Lord. Only I will know of all these things only when the information is supplied to me. Besides that, how will I know?
Yes.
My Lord, here it says. So this is where, my Lord, the post had fallen vacant. So, my Lord, the name of the school, Rajabala Deficit High Secondary School. So why my Lord has found the page?
Yes, yes.
So, my Lord, the reason for vacancy is death, my Lord. Now, here, my Lord, what it says? New post sanctioned by the Education Department. Assistant teacher. My Lord, it does not say SMS major or whatever. It's nothing stated here, my Lord. It says assistant teacher. Now, my Lord, what was the qualification, my Lord? Kindly see serial number B, name of teacher. What was the qualification, my Lord? Qualification is at serial number 2. It says BA B.Ed. This is the vacancy which is being filled up. This is the vacancy. Advertisement said something else. This is the vacancy, my Lord. What is the qualification, my Lord? BA B.Ed. No, my Lord, nowhere it mentions BA arts with SMS major. Nothing is mentioned. It says B.Ed degree. Only B.Ed degree with BA education qualification and B.Ed. This is the scale of pay, etc., my Lord. So, my Lord will kindly see. So, these facts, could I have known these facts before sitting for the exam, my Lord? Advertisement published in Ceylon Times, I have applied. As a bona fide genuine citizen, I have applied. Now, all these facts, could I have known, my Lord, from the day of what my learned friend is saying, that I fully knew that everything, this is a deficit school, B.Ed qualifications required. In spite of that, I took my chances. And then I did not qualify, then I have challenges. No, that's not the case. I have sat for the exams. I I was scared that maybe I may be disqualified. Why I was scared? Because I was not even aware, sure that, because this the terms and conditions of the advertisement says SME is major. I have applied. I was scared, skeptical that my application may get rejected. This explains my bona fide, my lord. It is not that I am not paying, I am not playing some clever card, my lord. This is a very bona fide, genuine intention. Because I was scared that what if my applications get rejected. But whatever is the case, thankfully my application got accepted, my lord. So for me to know that, my lord, this advertisement itself is defective initially, my lord, I could not have known it. It is only after participating and then later on it came to my knowledge. Now, just coming to the knowledge itself is not necessary. I needed required informations. Now, how do I get these informations? I filed RTI, I got these informations. And then, my lord, only thereafter I approached this honorable court. So, my lord, could the respondent authorities have deviated from this? Because you are feeling a vacancy. Because, my lord, will kindly see even the letter what it says. That even when vacancies are to be filled, it is to fill by that degree. I draw my lord's attention again to that letter, my lord.
All these aspects have to be brought out in your pleadings.
Exactly, my lord. See, my lord, it says, so my lord, I'm just reading, my lord. Further, the appointment against the deputation vacancies should also be made, even deputation vacancies, whatever vacancy. So, my lord, what was the vacancy that had arisen? The vacancy that it had arisen was a sanctioned post. And what was the sanctioned post, my lord? This was for an arts teacher with BA, BEd degree. That is it. No SMEs, major, minor, nothing like that. But this was the basic. That post ought to have been filled up. My lord, when I applied for the post, I was not even aware. I simply went by the advertisement. So once I have seen all these illegalities, definitely, my lord, if a certain law or process is not followed, it is my right. And there are also Supreme Court judgments, my lord, where the liberty is given to challenge, my lord. So that's exactly why I have approached this honorable court. And secondly, my lord, as far as the committee is concerned, it is understood, my lord. The committee is there. Naturally, the approval will also come. My lord, I will not go into that. Secondly, my lord, as far as the issuance of the advertisement. So, my lord, the post fell vacant. My lord, the post fell vacant on 12/9/2014. Exactly, my lord. I had stated October, but that's to be precise, my lord, 12/9/2014. The post had fell vacant. But what have you done? Why have you waited for 5th January to issue the advertisement? What prevented you from issuing the advertisement then and there? Let's assume 1 month. Why do you wait for such an auspicious? What is so auspicious about that date, my lord? That you issue the advertisement on the 5th. Why it is auspicious, my lord? My lord, it is because...
That could be because of administrative exigency.
No, my lord. My lord, from the record, my respectful submission, from the record. My lord, the wedding of the secretary, my lord's son takes place on the 4th. Daughter-in-law is, my lord, added into the family.
That is your presumption and allegation, but has no nexus really.
What could be the... my lord, that is my respectful submission.
Rejoinder, my lord, I cannot respond to this.
No, he cannot, because he did not.
So he cannot. He's stopped in law from raising this in rejoinder.
This, my lord.
Well, it's in your preliminary arguments, if you do not raise this, how do you expect us to reply? I cannot give a sir rejoinder.
No. This is already there.
I leave it to your lordships.
This is already there in the writ petition. I have stated.
If it's not pressed by him in the hearing stage, how am I supposed to respond to it?
No. I already informed my lord that let my friends submit further rejoinders I'll be giving.
Rejoinder is on law.
My lord,
should be.
My lord,
rejoinder is on law, not on facts.
No, wait, one second. My lord, this whatever I'm submitting is also there in the pleading, my lord.
Rejoinder is on law, my friend.
I'm not. Wait, 1 second. I'm not going out of the pleading, my lord. It is
I'm
not
not saying my friend is going out of the pleading. I'm saying rejoinder is on law. Rejoinder is not on bringing in new facts and new arguments.
My lord, there are times when the honorable court may simply go through the record and pass an order also, my lord, without hearing any party. So, my lord, this is already a part of the pleading. My lord, I have a right
Let
to
me
raise
finish.
that question.
I'm in
They
between,
may
Lordship, this
refuse
matter.
it.
I'm in between because there are two parts: the advertisement and the norms.
So they may refute, my lord. That's a different issue. But once I have pleaded, my lord, I have a right to raise this
Raised
issue.
it at the preliminary hearing. Nobody stopped you.
My lord, the hearing is still going on. It's not concluded, my lord. So, my lord, it is not a case. I am trying to only prove my bona fide, my lord. It is not that, my lord, I have stood. I knew everything from before. I participated, and subsequently, when it did not come in my favor, I went ahead and
Mr.
filed this case.
Versace, what you can
My
do,
lord.
you set it out in your written argument.
My lord, exactly.
Just one small submission. The way my learned friend, the petitioner, and the learned friend's client, the petitioner was very innocent, so was I. She responded to the advertisement, so did I. She did not know regarding the norms or the regulations of 2001, so didn't I.
Lordship, this
Have you filed your affidavit?
Well, I just have a one-line rejoinder to whatever my friend has said. Everybody is innocent, my lords. The fact of the matter remains, before filing of the writ petition, the eyes of the writ petitioner were opened. That is the admitted fact. The writ petitioner urges before your lordships, my lords, that the advertisement is illegal, it is flawed. And yet, my lords, prayer 2 is made before your lordships. Please appoint me against an illegal advertisement. I rest my case at that.
Lordship, in this matter, Lordship, I will not take side. But only thing, there are two parts. If we go by the advertisement, Lordship, the respondent number 9 is qualified. But if we go by the norms, Lordship, the petitioner is there. And also...
So what do we do?
We'll file a written argument.
My lord, we'll file a written argument.
Should we toss a coin?
We add both together. As on date, I have the qualification both as per advertisement, as per the regulations.
Even then, my lord. Even then, my lord.
No matter how much innocence we are pleading, we didn't know, we didn't do this. I didn't know it was a deficit school.
I've heard the parties.
My lord, why didn't you file the...
I've heard the parties. No,
I did not file the affidavit. Sue me for that.
No, that is exactly why I'm placing my objection.
It doesn't matter.
That is exactly I'm
My lords,
placing my
I am only on the limited issue. If the advertisement is illegal, my lords, can prayer be made?
It started from the advertisement, the problem.
If you admit, my lords, if my foundation of my case is that the advertisement is illegal, how am I making prayer be?
So that will be taken into account.
Exactly. Exactly.
So once, my lords, once I say that I should be appointed as against that advertisement on the same very selection process by removing respondent number 9, my argument of saying that the advertisement is illegal, that has no legs to stand on.
Anyway, finally, I'll go through what the parties have stated. But perhaps I think the process has to be restarted.
If it's
Most
legal,
that's
then the fresh process will...
For all, you see.
My lord, what has fallen from my lord? Now, even assuming, my lord, if the honorable court goes in that direction, my lord, my prayer would be, my lord, then it will include even the other, my lord, that the ages should be considered.
Now, all of them will be hit by those other norms. So, in my humble submission, my lords, that would not be a course
That has
open.
not been brought on record.
That would not be a course open, my lords, before this honorable court at this stage.
Yes.
But however, my lord, we may be allowed
We will go by the records and see.
and we may be allowed to file.
We'll file a written arguments, my lords. And only on this issue, my lords, I'll bring in, because this is an aspect of law, that the 2001 regulations, my lords, have been subsequently substituted by the RTA Act of 2004.
Yes.
So, under that, there are now new norms into place. So now, my lords, to say that, the entire process has to be restarted, my lords, may not be a course open before us at this stage. So it would have to be considered on the basis of...
2010 norms also is the same.
No, but now you'll have the MTET. MTET will come into play. It would only complicate matters further.
My lord, whether MTET is for the deficit schools or not, my lord.
This is for the secondary school.
Is MTET a substitute for BEd?
No, this is for the
MTET is in addition, my lords.
MTET is for the
MTET is an essential qualification.
That is a test in itself.
Yes. MTET, your lordships have held, is an essential qualification.
MTET for primary schools.
I will also try to.
That you see, it's open to the parties or the candidates to take part.
My lords.
So if you clear, then you You clear.
Then because now it has become an eligibility criteria.
Exactly,
If your lordships are deciding on that advertisement, my lords, then this
Lordship,
may not be an
in
eligibility
this matter,
criteria.
I think Lordship MTED is for the primary
I don't know.
schools.
My
I'll
friend
get the
You file your
clarification from that.
written
I'll
argument,
file
as well.
and the
yes.
court will consider. If reliefs are to be mold, yes.
Your lordships have to mold reliefs in this case. There's a fit case for molding of relief. My lords.
Thank you. So when do you file your?
My lord,
From date.
but, 1 week. I'll pray for 2 weeks, my lord.
Parties are heard in this case. The argument being concluded, it is submitted that written argument will be allowed to be filed in this case. As prayed for, this is matter after 2 weeks.
My lord, oblige.
Because if I may crave your lordship's indulgence, my lords, your lordships will be sitting in the second half.
Most probably.
Lords, I have certain matters, my lords. I am in little difficulty on the second half. Lords, if your lordships kindly
Okay.
accommodate us, my lords. With item numbers, my lords.
Second round of mentioning then, fine.
My lords, Friday evening, second half. I can only say this on behalf of the bar. My lords, 9, 10, 12 and 19, my lords. These are 4 matters which are there. Any date convenient next week, my lords, we can take it up.
Yes, who's for the
My friend is there, my lords. I think 9 and 10.
After 2 weeks, my lord.
Mention it. My lords, let it come after 2 weeks, my lords.
My lord,
I'll oblige.
my lord, there is item 18 also, my lord, which is at the hearing list. So, my lord, here we were to respond to the additional affidavit which is filed by the petitioner, my lord. That we have filed today.
I have received a copy of the same, Lordship.
So, my lord, the matter may come up of hearing some other date, my lord.
Yes,
You have filed the
The
rejoinder.
to the additional affidavit which was filed.
Respondent has responded to the additional affidavit filed by the petitioner, and accordingly, pleadings being completed, the matter may be heard, finally heard on the next day.
My lord.
2 weeks.
My lord, 2 weeks.
As prayed for, this is matter after 2 weeks.
My lord, in item number 11, my lord, the state was supposed, it is alleged to that fake encounter, my lord, where we are supposed to give the status of Tura PS case number 53 of 2015, my lord. I am placing it to the court master, my lord, for records, and I am also supplying a copy to the petitioner. My lord.
Even I am also asked to file a written argument. Though the hearing was concluded already, so my written argument also is ready, given a copy to the other party.
I'm submitting, my
So
lord.
you are filing your written argument?
Yes, no, we have already filed our written argument. They are filing it today, and we are also filing the status report of the police case, which my lord was.
So matter may be reserved for judgment.
Give to the court master.
This is my written argument.
Status report. So, my lord, it is concluded. Now it may be reserved for judgment, my lord.
Okay, 11 more. The learned counsel for the petitioner has submitted that the written argument has been filed today. Mr. S. N. Gupta, learned additional PP, learned additional senior GA, has submitted that the status report as regard what's the case number?
Number 53 of 2015, my lord.
To PS case number 53.
No, 50. 50 slash
Within
50
bracket 3.
53 of
2015.
15
under sections 120, 120B
has also been furnished. Accordingly, on submission made, this matter is now reserved for judgment.
Yes, my lord. Highly obliged, my lord.
Please, Your Lordship, I beg to mention item number 13. Your Lordship, we pray for 2 weeks' time in this matter as the learned DSGI has left the court premises due to some urgent personal work.
My lord, that is with regards to the they had to file that summary security course.
Okay, even that.
My lord. So let them, since the DSG.
That is just for, you are just to file that?
Your Lordship, we have taken instructions from the department, but they have not. We have not received any instructions from the department as yet.
On premier by the respondent, list this matter after 2 weeks.
Obliged.
I'll have this.
So what remains?
Your Lordship, I beg to mention item 21, Your Lordship. I pray that this matter may be taken up after 2 weeks, Your Lordship.
You are for?
The petitioner.
And for the state respondent.
On premier by petitioner, list this matter after 2 weeks.
May it please Your Lordship, we beg to make a joint mention, Your Lordship, item number 24.
On premier by the parties, list this matter after 3 weeks.
I am obliged.
My lord, item 23 and 25, senior counsel Mr. Kensing is appearing in that case. This will take some time, my lord. And from my side also it will take some time. So it's already 1:30. If both parties can be taken up after, because I don't
fatigue has set in.
My lord?
Fatigue has set in.
Absolutely, my lord. It's already Friday on top of it. So, on the prayer of all the parties, my lord, the matter can be taken after 2 weeks, my lord.
How long?
That will take some time, my lord. After 2 weeks, my lord.
2 weeks.
My lord.
On premier by the parties, list this matter after 2 weeks.
My lord. Obliged, my lord.
That's 23.
23 and 25, my lord.
23, 25.
Obliged.
So we are left with the Nehu matters. Ms. Paul will take it up after second half.
Lordship, the matter which your Lordship was hearing, that is item number 4, your Lordship.
Yes.
Lordship, in that matter, Lordship, the prayer has to be amended, your Lordship. Because these benefits, this MSCP benefit which accrued to him after the filing of the writ petition. He had filed it in 2015. This benefit accrued to him from 2016 onwards, your Lordship. So that portion of the prayer has to be amended, your Lordship. So if your Lordship kindly allows us to amend the prayer of the writ petition with regard to item number 4, your Lordship.
If the benefit accrues to you on in 2016,
Lordship,
you are coming before this court in 2023.
No, Lordship, we came before this honourable court in 2015.
No, for the amendment of the prayer.
Lordship, this has a bit, if your Lordship remembers, we have filed an additional affidavit where we have brought on record that similarly situated employees have holding the same post and enjoying the same benefits.
Yes, I remember.
Lordship, they are getting a higher pay scale. Now, this has been argued by the counsel for Nehu only on the last date, your Lordship. And Lordship, I am to reply to this as to why they have got a higher pay scale and I have not. The reason is because, your Lordship, this accrued to me from 2016 onwards. So at the time when I filed the writ petition, I could not have prayed for this. Now that they are raising an objection to this, that why they have accrued, they have received this and I have not, unless I amend my prayer, your Lordship, then I would be handicapped. Your Lordship will kindly appreciate.
Yes, Miss, what do you have to say?
Your Lordship, I leave it to the discretion of this honourable court, Your Lordship.
Item 4, Miss Paul and senior counsel appearing for the petitioner has submitted that 2015 is required to be amended in view of the subsequent development, particularly as regard the benefits under the MSCP, third MSCP scheme, which
Lordship,
which has accrued to the petitioner in the year 2016. As such, the required amendment is desired to be brought under court. The General Counsel for the respondent Nehu has submitted that the discretion of this court may be applied in this case. It is to be mentioned that this matter has travelled a long way since 2015. And as such, it is desirable for all concerned that the same be disposed of expeditiously. However, conceding to the prayer of the petitioner, the same is allowed, but it is to be noted that such application for amendment is to be filed definitely within the next date fix, for which no further time shall be allowed.
Lordship.
Agreed?
Lordship kindly allows 2 weeks time, Lordship, for amending this petition.
But no more time after that. Either you
Yes, Your Lordship.
do it or you
Remembering
forfeit.
Lordship.
As prayed for, this is matter to 2 weeks. All the other matters will also same.
No, Your Lordship. Lordship, because this 4 and 5 are similar, Lordship 6 and 7 are again totally different matters. So they'll have to be argued on their own merits.
Okay, so now
This is for 4 and 5, Your Lordship.
so this will be for 4 and 5.
Lordship. Because item number 6, Lordship, which has 2 matters, that is a totally different matter. It has no connection to these other.
So what do we do with 6?
So let it be after this is filed, Your Lordship, your Lordship can take up this matters.
Okay, 6.
After 3 weeks, Your Lordship.
6 and 7. This matter after 2 weeks.
Lordship. Obliged. Deeply obliged.